Hi, everybody. We're excited to be here today and talking with you about some essential estate planning for primarily for entrepreneurs and founders. Just a little bit of intros for me, Melissa, and my partner Carolyn. We work at Lake Street Advisors, which is a multifamily office. We work primarily for kind of first generation wealth families, focused on entrepreneurs, founders, business owners, and neither one of us are estate attorneys, but we have worked with families, I think, for 18 years, kind of helping them with their financial planning strategies, including what they want to do with their estate. Carolyn, do you want to say a couple words about yourself as well?
I'm really happy to be here. We think there's often a lot going on for executives and founders with their business, and our job is to look after the personal side of things, and the certainly estate planning falls under that aspect.
Great, thank you. So the objectives for today are really to talk about 5 different estate documents. There are 3 that are basic that we'll talk about, and then there are 2 that are a little bit more advanced. And what we want to cover is the purpose for each of them and how that fits into each of your planning. Discuss the major components and then practical considerations as you think about your documents and how you want to handle your estate. And then the last part is specific to this audience and clients like ours, which are founders and entrepreneurs. There's some specific planning ideas that you want to keep in mind. So there's 3 documents that are really basic and should be in place for everybody who's 18 years or older, and that's the healthcare proxy, the durable power of attorney, and the will. Carolyn's going to spend some time talking about what they are, and then also some kind of pitfalls that can catch you that you want to just think through. And then in addition to those 3 documents, there's 2 additional documents that we recommend quite a bit. One of them is a revocable trust, and that is something that we recommend, I think, for almost all of our clients. And then an irrevocable trust, depending on what the client is looking to do in terms of transferring wealth to extended family, to their current and future descendants, and then possibly charity as well. And there are some unique opportunities for founders and entrepreneurs when it comes to irrevocable trust that we'll spend some time on at the end.
So the first document we wanted to cover is a healthcare proxy, also known as the power of attorney for healthcare. This might be the most frequently used document potentially. The purpose of this document is it comes into play if you are unable to make healthcare decisions for yourself. If you're incapacitated, you are able to name someone to step into your shoes and do that for you. If you don't have one of these, medical professionals will work to keep you alive, but beyond that, no one else has the right to make medical decisions on your behalf. Your family would have to go to a court and be appointed as an agent or a guardian to be able to take control over that. So without one, you're potentially setting up your family for infighting. Your own wishes might not be respected. So this feels like a very simple document to have in place to avoid potential issues. This document too applies to anyone who's over age 18. So for example, when my son turned 18, we had him execute one of these. Part of our job is to worry about worst case scenarios and protect against them. And I certainly wanted to make sure that we would be able to speak to the doctors and make decisions on his behalf if something ever happened to him. So the things to keep in mind when you're executing or putting a healthcare proxy in place is you name an agent, one person that is going to make the decisions on your behalf. You can name successor agents as well in case the first person you name isn't available themselves. The second thing that you want to make sure is in your healthcare proxy is HIPAA language. So this is language that gives medical professionals the ability to share information with the person you've named as your agent. It's obviously pretty difficult for your agent to make decisions if they actually aren't legally allowed to receive information about your medical state. And then the final component of a healthcare proxy is a living will language. So this is the type of language where you can identify your preferences on life support or specific treatment desires. Power of attorney is the second document. It's kind of like a healthcare proxy, but for financial instead of medical decisions. So the power of attorney names someone to make financial decisions on your behalf. The reasons why you want to have that is if you are unable, whether through incapacity or simply not being available to execute financial transactions, someone can then make sure bills get paid, tax returns get filed, any other transactions for tax planning or investment purposes actually happen. If you don't have one, again, family members could go to court to get appointed as your attorney in fact for the power of attorney. Could cause potential family infighting, and perhaps someone that you would prefer not step into that role is the one who actually is appointed by the court. So always a better idea to set this up yourself and put it in place with your selections. So the components of a power of attorney to pay attention to are the attorney in fact. So that is the person who's stepping into your shoes to make financial decisions. You would also, here name successor people if the first person you name isn't available. Sometimes it can be problematic if you name them all in one document because the second person name would have to prove that the first person is not able to, and that becomes a little bit more complicated. So often we recommend having multiple durable powers of attorney in place, naming individual people. The power of attorney will contain a laundry list of powers that you're granting to this person. Particularly, we call to attention the gifting power, that your attorney, in fact, won't have the ability to make gifts on your behalf, which can be very powerful for tax planning purposes. We think it's important to pay attention to any language in the power of attorney about how the attorney, in fact, can amend the rest of your estate documents and want to go in eyes wide open on what abilities they have or don't have to do that. And since it's relatively new and the court system is slow to evolve, being specific about what happens and what powers you're granting over your digital assets, not just your financial assets, should be included in the power of attorney. Also within the power of attorney, you want HIPAA language. This is particularly important if you have a springing power of attorney, which we'll talk about in a moment. But this again is the language that allows healthcare professionals to share medical information about you. So if your power of attorney only comes into effect once you're incapacitated, your attorney, in fact, will actually need proof from your doctor of incapacitation, so that the HIPAA language is important to include. And the last thing to keep in mind with the power of attorney is it is effectively giving someone a blank check over your financial assets. So you want to be really thoughtful about who you give that to and how you control that. Often what we see is people who have executed the power of attorney have their actual attorney hang on to that document and let them be the judge of when it is needed to be used. So there's a little bit of control or have a gatekeeper in place. Actually, Melissa, can you jump back one slide? So I want to spend just a moment on the right-hand side about powers, different types of powers of attorney. There are general powers of attorney, which go into effect immediately and will actually terminate if you become incapacitated. At that point, a springing power of attorney goes into effect, but that's a different document. What we prefer to see is a durable power of attorney, which is in effect whether you have capacity or you don't have capacity. But there are three different documents. We think it's only necessary to have the one, but there may be circumstances where you're more comfortable with the springing power of attorney to put into place. And the last of the three core documents is your will, your last will and testament. So the purpose of this document is to appoint someone who will be responsible for settling your estate, typically called an executor or a personal representative. It's to name guardians if you have minor children who takes over parenting for your children. And obviously it's to direct what happens to your assets at your death. Obviously, I think a lot of people would say it's pretty important, even if they don't care so much about where the assets go, which they may care more about guardians for their children. So having a say about who raises your children and who gets your assets are really the reasons to have a will in place. If you don't have one, a court would decide guardianship for your children, and each state has their own special laws about what happens to your assets called, if you die without a will, called intestate laws. So those would govern, and that typically means your assets would be left to spouse and children. So the components of the will to pay particular attention to is the role of executor or personal representative. This is mostly an administrative job. There's not a lot of judgment or discretion exercise. So often this could actually just be your attorney who would exercise that role, because they're the ones who are likely going to be settling your estate anyway. In terms of naming guardians, obviously, if you're married to your children's parent, they would be your spouse would be the primary guardian. But it makes sense to also name an alternative if something happened to you and your spouse simultaneously. Often people name a sibling and a brother and sister-in-law. I think one thing we caution people to think through is if you name your brother and sister-in-law together, what happens if they're divorced or if one of them passes away? Do you want it to be just your brother, or your brother and sister-in-law only if they're still married and together, and if they're not, then you go to perhaps a different sibling and their spouse. So you can got to think through some of those iterations. And if you are divorced and have children with an ex-spouse, it really is worth a conversation to determine who a successor guardian would be if both parents have passed away. If you have conflicting guardians in your wills and both pass away, the last parent to pass away, their will govern. So you would want to sync up on that and pay attention to that. The will, when it disposes of your property, we want to make sure that not only have you other the bulk of your assets where you want them to go, but also any special bequests, any pieces of jewelry, artwork, heirloom furniture, other family heirlooms. You can specify where those go, either in a will or a letter that would go along with your will. And again, digital assets, we think it's really important to speak to those in your will and who gets what. And who is able to, at your death, step into your shoes to the extent that the various online providers will allow it. So it's important to make sure that the will has language that speaks to digital assets as well. Lastly, and this is more uncommon, but if you are a beneficiary of an irrevocable trust, you would quite possibly have the ability to exercise powers over appointing the assets at your death. That is done in your will. So pretty narrow set of circumstances, but if you are a beneficiary of an irrevocable trust, it's important to be thoughtful about getting that language in there.
So next we're going to talk about the revocable trust, which not everybody has in their basic estate plan. So some people will just use the 3 documents that Carolyn talked about. With our clients, we generally always recommend a revocable trust, and the revocable trust you can think about basically as an extension to the will. So the will is a document that you can use to outline how you want your assets disposed of and who you want your guardians to be for your children if you have any. The revocable trust basically does the same thing except for the guardian piece. You'd still want to do that in your will, but really it kind of takes over the direction of any assets. And so you might say, well, why would I have a revocable trust if I can just put it in the will? The primary purpose is that anything that you actually get in your revocable trust while you're living, so you actually retitle ownership from your personal name to your revocable trust, avoids probate. And probate can be expensive, and it's also public. So for business owners, one of the things that we think about is privacy of those business assets, including values and any kind of details, and then also how you might want the business succession to go. So having that titled in your revocable trust can preserve some privacy and also just some fees with administering. The other thing that it allows for is when you avoid probate, you avoid kind of assets getting frozen. So with a will, it needs to go through the probate court. That can take months to get through, and in that time frame, assets can be frozen. So if there's anything that's time sensitive within a business, and if the business documents don't actually speak to a succession of a business or who would step in, and instead your estate plan is speaking to that, then a revocable trust would allow your trustee to kind of continue on with business as normal, or at least as close to normal, versus having the business titled under your personal name. It could potentially get caught up in probate and then freeze some decisions. So those are the primary reasons, but you can really think about a revocable trust as an extension of yourself personally, and the same taxpayer as you, your same assets. You really don't kind of lose any control in a typical revocable trust. So some practical issues that we think about when setting up revocable trusts is the trustees, asset protection, flexibility, and then funding. So on trustees, you really want to think about who are the current trustees. Generally, that's always going to be the person who's the funder, who kind of took their own assets and put it into trust. So it's really who do you want to be successor trustees if something happens to you, if you're not able to serve either from incapacity or at death. And then if the trust is designed to last a long time, say for example that it lasts after something happened to you, and if you're married, something happened to your spouse, some of these trusts can be designed to leave assets in trust for your children and grandchildren's lives. So if it's designed that way, you want to kind of think through the trustee powers. So it's not just naming, a person as a successor, but it's also naming who has the right to appoint the future successor beyond that, and who has the right to remove. So we often spend a fair amount of time there. And then specifically for business assets, you might want to think through who might take over voting rights. And that can be different than maybe who's kind of dealing with any tax issues or anything like that. So trustees is definitely one of the more important items. When it comes to asset protection, while you're living and while it's your trust, there really isn't any asset protection. The assets that are in a revocable trust are generally considered yours, unless it's a special trust that's designed for asset protection. Generally, there isn't any. So it really is thinking about asset protection after your death. So money that's left in trust generally has a higher level of asset protection than money that you leave outright to your beneficiaries. So you can think about, if you end up setting up your plan and you're leaving assets to your kids, if they were ever in a car accident in the future, and they were the cause of that car accident and they got sued, assets in the trust would have a higher level of protection than assets that they held in their personal name and received from you. And then the last piece is using non-binding memos, which is a technique that we'll use if clients want to retain some flexibility but still provide some direction to their trustees about how they might want assets to be distributed. So an example of that might be allowing your children to buy a house, allowing your children to use some of the trust assets for a business, just kind of giving some general guidance. But because some of these trusts last for many, many, many years, sometimes you just can't predict what's out in the future. So rather than hardwiring something into the trust, you can just give general guidance and then let the trustee make the ultimate decision at the time, taking kind of everything into account at that time. The next piece is flexibility. So just thinking through how much flexibility you want to add in your plan. And this is really kind of thinking beyond your life. and trying to predict how long will this trust be around. Could it be around for 100 years, 200 years, for grandchildren, great-grandchildren? It's really impossible to know what the world might look like then. So there might just be some areas where you want the trustees to have some flexibility to adjust. And then funding, as we mentioned on the prior slide, the primary purpose really is to avoid probate. So it's as simple, but it is definitely administrative to actually retitle your assets. So that's going to your bank account, your brokerage account, and taking assets or accounts that are in your personal name and instead actually registering in the name of your revocable trust. And that's the only way you avoid probate, is if they're actually in the name of the revocable trust. Anything that's in your personal name would go through probate. And then the last item that we wanted to mention here is there are some assets that you might own that really don't get disposed of through your will or your revocable trust. And an example of that is a retirement account or life insurance. They have their own way to designate the beneficiary. So that's just something to kind of think through about who the beneficiaries are on kind of those other assets. And it also might be any kind of deferred compensation plan, possibly, if it's structured through your business, that you want to just look to see if there is a way to name a beneficiary there. So on the irrevocable trust side, this one, you'll see on the next slide that a lot of the things that we think through are very similar, but the reasons why you might have an irrevocable trust is different than why you would have a revocable trust. This one is generally established because you're trying to transfer some of your own wealth to a trust for the benefit of somebody else. So that could be your spouse, and your current and future descendants. It also can include charity. It could include extended family, but generally these are designed where you're trying to transfer something that you own and kind of set it aside for the benefit of somebody else. This similarly avoids probate, but it also can be set up to avoid estate taxes. So a revocable trust, the assets that are in that are still inside your estate. So when you die, the federal government and some states will put their hand out and actually charge an estate tax. With an irrevocable trust, generally, if it's not for your benefit and you haven't retained control, then it will generally be outside of your taxable estate. So a lot of our clients will take some of their assets, put it into irrevocable trust for their kids and grandkids, and then really kind of let the trust grow over time and have it outside of their taxable estate. So without one, generally it's a missed opportunity and potentially on both asset protection and also tax savings. Right now there's a lot of talk about the estate exemption levels and whether people are going to use them if there's a change. Right now we know that there's going to be a reduction in the exemption levels at the end of 2025, but there is talk about it possibly happening sooner. So the biggest item is really just missed opportunities if you don't do it. So the practical issues, the first three you'll notice are basically identical to what we mentioned on the revocable trusts. I would say on the irrevocable trust, it can be a little bit harder to modify an irrevocable trust versus a revocable trust because it just the name kind of says it's irrevocable. So once you do something, it's just harder to modify. So you really do want to, at funding or at creation, you really do want to be thoughtful about the provisions here because it's not always possible to change them like it is with a revocable trust. The one box that's different with an irrevocable trust versus the revocable trust is the funding strategy. So here, if you transfer assets that are yours to an irrevocable trust for the benefit of somebody else, generally that's considered a gift. So you have to then think about, is there gift tax? Are there gift tax returns that you need to file? In addition to gift tax, there might be GST, which is generation skipping tax. So that's really if you're trying to pass assets beyond more than one generation. And then there's also some other strategies other than just making a gift and using up some of your exemption, or even just making a taxable gift. There's other strategies that you can use, such as a sale with a discount if it's a business asset, and there's reasons for a discount. And then there's some other techniques here. We mentioned a GRAT. I think Carolyn later on will spend a little bit more time on the different strategies. But it's definitely important as you think about funding an irrevocable trust to make sure that you just understand what you're doing and work with the estate attorney and possibly your CPA, whoever is going to file the return, to make sure that all the correct filings are being done from a tax standpoint. So some issues and opportunities that are unique to founders and entrepreneurs. You know, the first area that we always start with is really not trying to let the taxes kind of drive the purpose. Instead, we always try to understand with the families we work with what the purpose of their wealth is. And we really think that that's important because working with individuals, which is all we do, you know, people have different objectives, and it doesn't, what one strategy is used for one family might not work for another family because their objectives are different. So, and an example of that is we have some families who, you know, kind of want all of their assets to be left to children and grandchildren. And then we have other families who want a certain amount to be left to their children and grandchildren, but then they also want a certain amount to be left to charity. And it really just depends on what the family is trying to accomplish. And then we also, you know, want to make sure that before people get too excited about kind of transferring wealth that they might need during their life, that they just kind of understand their own needs and how that might change. You know, after if, for example, if a business owner, you know, was working and making an income and then retired and had a sale, and then maybe their lifestyle starts to change through travel or potential health issues, just kind of thinking through whether you have enough assets of your own. Kind of once we solve what the purpose and the objectives are, then we look at the unique strategies. And one thing that's unique for founders and entrepreneurs is generally there's the possibility to transfer assets with an early or low valuation, pre-liquidity, so you can get some discounts, and you know, just be thoughtful about how you use your exemption. In addition to the estate and gift strategies through the wealth transfer, there's also some income tax planning. So QSBS is something that is for qualified small business stock, and this one's you know, pretty powerful because the general idea is that for any taxpayer who has an investment in a qualified small business stock that meets the qualifications that are needed, you can avoid up to generally around $10 million of capital gains, which can be huge. And then there are abilities to multiply that with multiple taxpayers. So, for example, you could have a business owner who has an investment in their company that qualifies as qualified small business stock, and then that business owner could make a gift in the early days of a piece of that company to a trust that's a different taxpayer, and then the trust would also get a $10 million capital gains exclusion. So it can be pretty powerful planning here, and definitely unique to the people who kind of have investments in these businesses that qualify. The other piece on the income tax side that's unique is this says situs of the irrevocable trust, which really just says where is the trust located for income tax purposes. We're in a tax-friendly state of New Hampshire, but not everybody is. So there are some considerations to be given as to where the trust is. The next piece is the variability of future wealth. So this is definitely something that's unique to founders and entrepreneurs. You know, sometimes they just the range of outcomes for their business can be very wide. So just thinking through what the future might be, and if it reached certain levels of value or wealth, would that change your plan? So there can be strategies where you actually include safety valves. So if the future wealth, reached a certain amount, maybe that's when you introduce leaving something to charity or providing something for extended family. And then also the piece about liquidity. If it is a business that's going to be held through death, then just kind of thinking through whether the estate will actually have enough liquidity to pay for the taxes, depending on what the value of the business would be. And then the last thing I note here is just timing. So whenever we do planning with clients who kind of have these opportunities, if there's a liquidity event on the horizon, sometimes if you wait too long, then you start to kind of increase your risk from a tax standpoint about whether you can take the discounts and whether a transaction is already considered to be basically kind of definitive. So it's something that you just need to be mindful of and make sure that you start planning in advance of getting too close. And if you can, ideally kind of spread it over 2 tax years, if not more. So I'll turn it over to Carolyn, who will talk a little bit more about different types of strategies.
So just to maybe start by expounding too on what Melissa talked about in terms of identifying purpose. We often first meet people and hear them ask, hey, my company is growing. Should I do a GRAT? Should I fund a SLAT? And they kind of jump to whether they should implement a specific strategy before they flesh out what they really want to accomplish. I think if you ask, most people would say that savings taxes is a pretty high priority for them. And I think, that's a relatively easy goal to accomplish, but at what cost is the question. So before jumping into these alphabet soup trusts that you see on the right, I think there are some pretty important questions that you should ask yourself about how much control are you willing to forfeit on the assets? How much complexity are you willing to accept? And for complexity, what we mean is both kind of understanding the structure of your family entities, but also the costs of maintaining that, of having accountants and attorneys who are, and advisors who are looking over that. There's an ongoing cost associated with that. And then how important is it making sure you have sufficient assets to live out the rest of your life the way you might want to? So before you give everything away, it's the oxygen in the airplane. Make sure you've taken care of yourself first. Once kind of someone has been able to articulate their comfort level in those areas, then it's pretty easy from that point to identify which strategies would make the most sense. Each of these strategies has unique trade-offs that are beyond the scope of this discussion, but we've tried to capture them here. We've ordered a GRAT, a grantor retained annuity trust, as a fairly low complexity type of strategy that transfers future appreciation to people, to extended family or to children. A SLAT is a spousal lifetime access trust, which is also a type of trust known as an intentionally defective grantor trust. What that gets you, as you can see in the column, most everything on people's wish list except for state income tax savings. And as you go across the right, there are the trusts get a little more complex and a little bit more involved. But these are the kinds of the typical strategies that you would typically consider if you have a company that is expected to have significant future appreciation and are looking to do some wealth transfer. We appreciate everyone's time in listening to this. Obviously happy to answer any questions people have after they've gotten to this point. Our contact information is here and on our website at lakestreetadvisors.com. But we thank you for listening.